Right, just give me a second because I can't hear anybody. Can everybody hear me?
Yes, sir. Good afternoon.
I can hear you. Thank you. Let's just wait for the other judge. And then we will start. I should say good morning to everyone, or maybe good afternoon where you are. It's the morning here in England. Just waiting for my co-judge. Let's give him a couple of minutes. Can I just check whilst we wait for my co-judge? Firstly, that we've got a senior appellant. We have that you, yes. That we have a senior respondent.
Yes, that would be me.
Excellent. A junior appellant.
Yes, that would be me.
And junior respondent.
My teammate, she has difficulty into hearing the meeting, although she can get into the call, but she cannot hear or speak. So she is trying to amend this faulty right now.
Okay, that's fine. Let us know. I'll check before we start what your situation is. I mean, she's
Yes.
mercifully, you've got the senior appellants and senior respondents time first, so you've got some additional time to work out if you can solve your technical problem.
Yes. She delivers her apologies that she is trying to link in through her laptop because it failed earlier today, and yes.
That's fine. That's the nature of remote.
Thank you.
Remote hearings.
Hi, Jonathan, I guess your teammate joined?
No, she has not.
Okay, because actually I was seeing her name in the participants list. That's why I asked.
Because now when I'm looking at the participant, her name is not there.
Yeah, actually it was there like a few seconds before. So yeah, that's
I saw that as well, but she said she cannot hear anything that when we talk.
Okay, I can talk to my tech team then, and they might
Okay.
help you. So you can ask her to join the meeting, this session, and in meanwhile, I'll just contact my tech team. We can see if they can help her out.
Okay, thank you.
Yeah.
So yeah, she has joined now, but I believe that she cannot hear anything that we're saying.
Okay. She cannot hear anything, or actually, I think I am just seeing that her voice notification is not there. It is disabled. I guess so.
Yes, I
So
saw that as well. So I'm just going to tell her if she can turn on her notification.
yeah.
Good morning, everyone. Good morning, Matthew. This is Delvin here.
Morning, Delvin.
Just wanted to say hello. Just wanted to say that the other judge, Srikant, he should be
Yes,
joining in like hopefully 5 minutes.
that's fine. We've got a
So
technical problem, as you've
okay,
probably
well,
detected,
good.
with one of the participants. So we're just
Okay,
waiting 5 minutes to see if we can sort that
all
out.
right, perfect. All right, thank you. Thank you, and good luck to everyone.
Thank you, Delvin.
My teammate has just messaged me about her situation, which is when she joined the meeting and when she tried to turn on the voice notification thing, uh, it it just does not let her to do so, and we'll just disconnect from the meeting automatically.
Hi, I'm so sorry for the delay. I had back-to-back rounds before this. That's the reason why I got a bit delayed. Have I
Don't
missed?
worry. We've got a technical issue that we're just trying to resolve with one of the participants. So we have paused things for 5 minutes, which may give us a delay. I think, Jonathan, can you hear me?
Yes, I do.
Are you in the same room as your fellow participant?
No, we are not.
Oh, you're not. You're not. There's no way of her
Yeah.
using your computer.
Yeah.
Okay.
So,
Because I think if we don't start relatively soon, we're going to the whole competition for everybody is going to be behind.
I do understand. So, if it so happens for the worst case scenario, is it possible for me to argue on second grounds of appeal as well?
Yes, we can do that. If there's no other way of your colleague joining this
Yeah.
meeting, then I think that's the best thing to do.
Yeah. I would just message her. So, when would you possibly reckon to be the final time for the start of the competition?
We'll say 1/4 past. It's 12 minutes past
Okay,
now.
thank you.
Whilst you're waiting, senior appellant, do you want to tell me how your team is going to divide up its time?
Good afternoon, sir. The appellant side, we intend to keep 5 minutes each of us for rebuttals.
Okay.
5 minutes each. So that gives us 20 minutes. 5 minutes each, 35. We take 17 minutes each speaking time.
Yeah, that's fine.
It would be the same for me as well.
That's absolutely fine. Yeah, well, you don't have rebuttal, so you can just have your.
Okay, yes.
20
Sorry,
minutes.
no apologies.
I think Webinar have just posted an alternative link to this meeting, Jonathan, that your team member can use. Well, welcome everyone. I think we'll get started. Could I invite the senior appellant to begin his team's submissions?
Greetings, the members of the bench. I am Madhuk Chaturvedi, counsel for senior appellant. counsel for the appellant, Mr. Leith Payne, and I shall be addressing the first ground referred to this court. My co-counsel, Friana Gazzer, shall be addressing the second ground of appeal. Your Honors, my client, Mr. Leith Payne, had entered into an electronic contract with the respondent through an online trading platform called Clevity. The issue at hand regards a cryptocurrency called Yapple, under which the parties had been trading on the Clevity platform. The Clevity platform operates on blockchain technology using nodes, probably hundreds of nodes located worldwide. One such node from the network is located in the premise of the DIFC. The platform allows algorithmic trading, which has been a usual practice for financial markets since the 1990s or even before, and to protect against errors and errors on the system, the platform requires...
This meeting is being recorded.
Sorry for the interruption. The platform requires all users to have a minimum cash balance of US dollars for 50,000. Regarding the algorithmic trading, both the parties have their respective softwares which perform trade for them. The appellant's software program Beta is created to offer to sell Yapple at the average price of all the sellers in the market, and in the absence of all the sellers, at an inflated price to earn a better profit. The respondent's program Alpha, buys Yapple at the best available price on the market. Now, during regular maintenance of the Clevity platform on 10 June 2022, the maintenance team, in an error, they increased the minimum cash margin to 200,000 US dollars. Under the terms and conditions of Clevity platform, any user below this minimum cash margin is automatically excluded from trading. Thus, the only two users on the platform remaining were the respective parties of the dispute. Though this error was rectified within 30 minutes, the programs Alpha and Beta concluded an electronic contract to sell Yapple for 250,000 US dollars. It is undisputed between the parties that this was concluded at 250 times the prevailing market prices. Both the parties were asleep and ignorant of the activity going on the platform during the time which Clevity autonomously settled the transaction by transferring the relevant monies and coins to the parties. It must be noted that DIFC is not the residence of any of the parties. The respondent resides in Dubai, not in the DIFC, whereas the appellant resides in the Sultanate of Oman. With these essential backgrounds, the counsel would introduce the first ground of appeal, being that the Dubai International Financial Center branch of the Digital Economic Court does not have jurisdiction to hear the present dispute. Supporting this point, counsel has two submissions to make. Firstly, regarding the relevance of the node present in the DIFC to establish jurisdiction, and secondly, the interpretation of Article 5A1B of the Judicial Authority Law of the DIFC. Beginning with my first submission regarding the relevance of a node in the DIFC. Now, a distributed ledger system is a decentralized system that supports recording of encrypted data on a network of computers or nodes. Now, this definition is backed up by the Dubai Financial Services Authority in its glossary module, version 54 of January, March, April, May of 2022. Now, each node on the network is meant as a processor of information. a processor of information which enters into the network and also which exits from the network. Now, this is backed up by paragraph 29 of the UK Jurisdiction Task Force's legal statement on crypto assets and smart contracts. Furthermore, it is internationally accepted that the presence of a host of a node in the premises of a court does not provide jurisdiction. The council would like to refer to the case of Alibaba Group Holding Limited and Alibaba Coin Foundation of 2018 of the Southern District of the New York. The case can be
why is a decision of a US court about the jurisdiction of a US court relevant to the DIFC court?
Your Honor, the DIFC presently does not have cases or precedents regarding the jurisdiction in regards to crypto assets and cryptocurrencies. Hence, the council has to rely on international cases to present its arguments.
So does the relevant US court have a similar basis for jurisdiction to the DIFC courts? I mean, is it a comparable sort of jurisdiction? Because, for instance, the English courts' basis for their jurisdiction is service, which is a completely different jurisdictional foundation to the DIFC. So one can't necessarily rely on English case law about jurisdiction. So why do you say that the DIFC court should look in particular at a decision of the US court?
Your Honor, the New York cases follow a common law system, and as well as the UK follows a common law system. The New York courts, the jurisdictional requirements in New York court are more generalized, as in the sense of them requiring subject matter jurisdiction and personal jurisdiction to be satisfied, which is similar to the case in the DIFC, where the subject matter is regarding contracts and commercial decisions, and personal jurisdiction under the judicial authority law and other relevant laws of the DIFC, which the council shall refer to in further submissions. Hence, continuing with my submission, the Alibaba case had the issue regarding whether the host of a website can give jurisdiction to the court of that location, of that premise. The New York court held that the presence of a host of a website does not give jurisdiction, and this can analogically be applied to the current case, as the node is in a sense a host of and is a location for processes of the location for recording and transmitting information on the network, thus similar to the operation of a host for a website. Hence, the appellant contends, my apologies, the appellant contends that DIFC does not have jurisdiction by merely the presence of a node in the DIFC premises. This concludes my first submission. Moving on to the second submission regarding the interpretation of Article 5A1B of the Judicial Authority Law, which was referred to and depended upon by the first court of first instance of the Digital Economic Court. Article 5A1B states that civil or commercial claims and actions arising out of or relating to a contract or promised contract, whether partly or wholly concluded, finalized, or performed within the DIFC, or will be performed or is supposed to be performed within the DIFC pursuant to express or implied terms stipulated in the contract. The interpretation of this statement must be in line with other DIFC laws, which provide guidance upon the application of DIFC laws, right? The laws the council shall refer to are the DIFC law number 10 of 2005 and DIFC law number 3 of 2004, which provide guidances and prescribe tests to establish jurisdiction for claims being heard in the DIFC courts. To begin the analysis, it is internationally accepted that crypto assets and cryptocurrencies are properties. They satisfy the definition of property, which was provided by Lord Wilberforce in the UK House of Lords. The international acceptance arises from the case of Rusco and Cryptopia Limited of the New Zealand High Court in 2020, as well as the AA and Unknowns of the England and Wales High Court in 2019, where both of them jointly said that crypto assets and cryptocurrencies are regarded as properties and can be and satisfy their respective definitions. Hence, because these crypto assets are parties and cryptocurrencies are properties, a part 5 of the DIFC law number 10 of 2005 applies. This law can be found on page number, just a minute, on page number 17 of the bundle, which on page number 18, the council has highlighted the relevant tests prescribed in the article. Article 16.5 of the law number 10 of 2005 establishes jurisdiction tests in commercial contracts. Thus, upon application of the facts of the case, subparagraphs A, B, and
which are you looking at the paragraph 16.2 that starts the law of an investment intermediary's jurisdiction governs?
Yes, Your Honor, exactly that, please.
Is that not dealing with governing law rather than questions of jurisdiction?
Of an intermediate jurisdiction governs. Well, this article, the law 10 of 2005 is assistant in prescribing tests for establishing jurisdiction, as the requirements of this test are relevant to the judicial authority law and are referred to by scholars. Hence, on application of the facts of the case, subparagraphs A, B, and C, where they fail, as they require express agreement among the parties on the jurisdiction, which in the present case there hasn't been any. And nor is there an evidence regarding the physical addresses of the parties' accounts on Clevity's platform, nor is there then any evidence of Clevity's head office. Hence, because these tests fail, the test in law number 3 of 2004, which can be found on page 16 of the bundle, is 16 of the bundle, where Article 8.2 my apologies, Your Honor, it is page 14 of the bundle, where Article 8.2 stipulates 5 criteria to establish jurisdiction. Again, as the wording is very similar to the laws regarding which law governs the contract.
Again, is this not dealing with the governing law of a dispute? So the law that the court has to apply, rather than whether this particular court has jurisdiction over the dispute. Because Article 8.1 makes clear that the law that the court is to apply is the law chosen in accordance with paragraph 2. So this is premised on the DIFC court having jurisdiction and then needing to decide which law it has to apply to resolve the dispute.
Your Honor, as you have rightly mentioned, that Article 8.1 refers to the law governing the dispute. However, there is scholarly articles which indicate that these laws assist in and are persuasive to the court in determining the jurisdiction of the court. Hence, these are being relied by the council.
Which scholarly articles are you referring to?
Your Honor, at present, the council is not able to provide a list of those articles. However, upon request of the court, these can be provided in a written brief. Hence, based on these tests, subparagraphs A, B, and C fail because there is no express agreement among the parties of any jurisdiction. And hence, in paragraph D, the close connection test is applicable. Regarding the close connection test, the Canadian Supreme Court, in the case of Imperial Life Insurance and Colmenares of 1965, states that residence of the parties is the important criterion in establishing whether there is close connection. It must be reminded that neither of the parties reside in the DIFC, and hence it is contended that the DIFC does not have jurisdiction to hear this case because the close connection test fails. In conclusion, the presence of a clavities node in the DIFC does not substantiate the first instance court's argument of the contract, of the disputed trade contract being concluded, finalized, or performed in the DIFC. Lastly, the court must interpret Article 5A1B of the Judicial Authority Law in line with other DIFC laws, which provide rules for application. And hence, the counsel pleading to the court to allow this appeal and overrule the decision of the first instance court. Thank you.
Thank you very much. So I would now like to invite the senior respondent, please, to make your submissions.
Yes. So, would Your Honour benefit from rehearsal facts?
No, you can take it as read that we know the facts.
Okay. So, based on the law of the relevant mistake, is that a party can only avoid a contract for the mistake of when the contract was concluded. The mistake was of such importance that a reasonable person in the same situation as the party would not have concluded it all of the
Can I just check you're dealing with ground
had been known? Yes.
So
it would
you're
be
dealing with
the
ground
Article 37,
one on just
ground for the second ground of appeal. That it will not be sufficient that for the court to believe that it had erred in concluding Ms. Bassi believing she was a reasonable traitor.
Right, can I just check you're dealing with ground one on jurisdiction?
Oh yes. Okay. Because like my learned friends had he had named the second one first. If it is regarding the first ground of appeal, I can proceed right now, and then I can come back to the second ground.
He dealt with the first ground, which was the question of jurisdiction.
Oh, okay. Maybe I was hearing things. Oh, sorry. Many apologies. So yes, I will be arguing on both grounds, so it's a bit confusing for me. And so according to the Article 5A1B of the FC court law, that's the court of first instance shall have exclusive jurisdiction to hear and examine civil or commercial claims and actions arising out of or relating to a contract or promised contract, whether partly or wholly concluded, finalized, or performed within the DIFC, or will be performed as it is supposed to be performed within the DIFC, pursuant to express or implied terms stipulated in the contract. As the brief facts being mentioned by my learned friends, that one of the nodes of the distributed ledger operated by Clevity was in the DIFC. And it therefore suffices to what I've just mentioned of the legislation of partly or wholly concluded, finalized, or performed within the DIFC. And therefore it is, and therefore the jurisdiction of the DIFC is authorized to deal with this disputed trade. And as
Why?
quoting from our core, because one of the nodes of the online platform is operating in Dubai. It therefore means that the transaction, the contract, the electronic contract to be precise, is also conducted in Dubai, and therefore it suffices with the partly or wholly concluded, as I've said in the legislation of Article 5.
So you rely on the conclusion, not the finalization or performance. Is that right?
Yes.
So, and you say the presence of the node means that the contract is partly concluded in Dubai. If the node,
Yes,
as your opponent says, is just a means of recording a transaction, why does that mean that the mere presence of the node means that a contract is partly concluded in the DIFC?
Because with in Dubai, and the algorithm that has been written is also written in sense to suit the Dubai contract law, then therefore it is concluded into the IFC jurisdiction, as Mr. Payne is in Oman, but the platform, the online platform, it has a note in Dubai, and although it is one of the nodes that is separated in the world, but with both parties, with one of them is in Dubai and one near Dubai, it would seem more probable and reasonable that it is directed into the Dubai jurisdiction.
Imagine hypothetically that the particular node that is in the DIFC wasn't working on the day when this transaction took place. That doesn't prevent the ledger from operating, because all the other nodes continue to record the transactions that are taking place. But would that mean that because the particular node wasn't engaged, that the DIFC court wouldn't have jurisdiction over a transaction? And are you submitting, therefore, that the DIFC's jurisdiction might happen in any particular case simply to turn on whether someone had switched on a node or not within the DIFC?
I would conclude. I would say that as from our Kuravi and Bang Saracen in paragraph 29, subparagraph 6. Accordingly, under the article I have just mentioned, that the IFC courts had exclusive jurisdiction over all claims arising from or related to those contracts. So if it is related to, if part of it is related to whether or not if the node is being turned on or off, I deem not possible to be the determining factor, because if there is a node, in Dubai, and this transaction was in majority based on depending on this node and in its jurisdiction, then whether on that day the node is turned on or off, it does not really include into it does not really jump into the conclusion of because on that day it was not performed in that jurisdiction, and therefore it is directed to other jurisdictions.
Okay, you can carry on with your submission.
Yes. So as I was saying that in my quoting of Al-Quravi, the partial performance of those contracts within the DIFC was not carried out by either parties that are not in Dubai on its behalf. The claim against the former, which is the party that is not in Dubai, from or arose from or related to a contract with it partly implemented on its behalf in the DIFC. And this thus showed that the entire operation does not need to be based in the DIFC in its jurisdiction, but it can also have, it also allows to have international defendants or claimants, and in this case is Mr. Payne being in Oman. So therefore, the DIFC court can have the jurisdiction over the claim of Ms. Rassi, the respondent. And that would conclude my responding towards the my learned friend's submission.
Thank you very much. In which case, I think the senior appellant, has your 5 minutes, up to 5 minutes of rebuttal, and then we'll hear from the junior counsel.
Thank you very much, Your Honor. In an attempt to rebut the statements made by the responding counsel, the appellant counsel would like to restate that the presence of a node has popularly been held irrelevant in establishment of a jurisdiction. Furthermore,
why is it? What was the? Can you tell me what was the key reason why the U.S. court held that the presence of a node was not sufficient to enliven its jurisdiction? What was it about the node?
Yes, Your Honor. Thank you for that question. I was wishing to address that analogy shown by the Alibaba case in the judgment. The analogy was that if every node located worldwide started giving jurisdiction to the relevant places, relevant countries, users could go around jurisdiction shopping and bring claims in any jurisdiction they wish, just because there is a node present in that area. Like example, the parties in the current case are...
Even the contrary also exists. I mean, having a presence in every country can also result in no jurisdiction, so to speak, and no dispute being settled because of the fact that you cannot trace it back to a node. So we have to establish, or rather ensure that the floodgates are there.
Yes, Your Honor. Regarding that, just the issue is that a presence of a node does not give jurisdiction. However, the location of the head office of the platform, say in the present case is the platform Clevity, at the moment the parties do not have information regarding the head office or the country in which it is located. If such information was available, that country would most likely have the jurisdiction to hear the present case.
Can I
Currently,
the question a little further? So, would it be possible for me to take a look at their tax information and perhaps establish a permanent establishment as per the BEPS, the base erosion and profit sharing, and establish that that jurisdiction has the power to determine the disputes that would arise in this particular case? I'm just extending your because when you talk about the head office, then that naturally leads me to understand how tax works and where would you tax it?
yes, Your Honor. There has been a case, if I may refer to the Canadian Supreme Court case of Imperial Life Insurance and Colmenares, where the judge referred to the location of the party's domicile, the place, the jurisdiction where the party has been domiciled for possibly tax purposes and other purposes as well. That jurisdiction will be the relevant one to hear disputes regarding the cryptocurrencies and international contracts. Hence, at present, presently, the parties are domiciled in Dubai, UAE, and in Sultanate of Oman. Hence, giving preference to the location of the defendant under the natural laws of justice, the jurisdiction of Oman, the Sultanate of Oman, is most likely to have jurisdiction to hear this case and not the DIFC. This concludes the rebuttal from the senior appellate, unless the judges have any further questions. Thank you.
Thank you. There are no further questions from me. In which case, we will then move on to the junior counsel. And I would invite the junior counsel for the appellant to begin the submissions.
Okay. May it please the court, as previously introduced by my learned senior counsel, Mr. Mother, my name is Friana Ghasta. I will appear as the junior counsel for the appellant, Mr. Leith Payne. Your Honours, I will address the second ground of appeal and attempt to convince this court to invalidate the decision of the judge in the first court of instance and further support the argument of my co-counsel. As a result of this, confirming that in the case of Raz Rani, the respondent, and Leith Payne, the appellant, the court's conclusion based on the reasonable man test was incorrect. On the basis that a unilateral mistake cannot invalidate the disputed trade, since the appellant did not have any constructive knowledge of the respondent's position, this submission will be made opposing the respondent's views. The second ground of appeal simply implies that did the first instance court err in concluding that for the purpose of the claim to be avoided or to avoid the disputed trade, it was sufficient for the purpose of satisfying Article 37(1)(a) of the DIFC contract law that Ms. Razi shows a reasonable trader with knowledge of the circumstance surrounding the transaction would have concluded that the dispute trade was a result of an error. The submissions I would like to put forward, in this case, Your Honor, I would want to present my submission in response to the second ground of appeal mentioned above. If it may please the court, I will now proceed with my submission. Your Honor, the first instance court did err in concluding for a claim to avoid the disputed trade. It was sufficient for satisfying Article 37(1)(a) of the DIFC contract law that the respondent shows that a reasonable trader with the knowledge of circumstances surrounding the transaction would have concluded the disputed trade was a result of an error. In other words, it is not sufficient to show that the appellant was a reasonable trader had it had constructive knowledge of the mistake, which he didn't. Instead, the court should have examined the programmer's state of mind while he was designing the program. Therefore, Article 37(1)(a) of the DIFC contract law states the other party made the same mistake or was mistaken or caused a mistake or knew or have ought to known of the mistake. It was contrary to the reasonable commercial standards of fair dealing to leave the mistaken party in error. Therefore, based on Article 37(1)(a) of DIFC contract law, there cannot be relevant mistake, as even if the respondent did make a mistake when the appellant programmed better, he did not make the same mistake as the respondent, or even cause her mistake, as he did not know or could not have known about the respondent's mistake. Therefore, Mr. Payne could have not even imagined or foreseen any mistake made by Ms. Razi. Hence, no grounds to avoid the disputed trade could have taken place. And
Doesn't
even
your
if we
doesn't
see,
your doesn't your argument turn on what is the right time frame for knowledge? So leave aside whether the other party made the same mistake or was also mistaken or caused the mistake. We're looking just at those words, or knew or ought to have known of the mistake, and leave aside actual knowledge. So ought to have known of the mistake. So that is, would a reasonable person have known of the mistake? So the issue, doesn't it, turns on when the relevant knowledge is to be assessed. So why do you say that the knowledge ought to be assessed at the time of programming rather than at the time when the trade is concluded?
the reason I say so is because if we look at the entire case standpoint, when beta was programmed per se, it was programmed in such a manner that it would automatically offer YAPL for a highly inflated price on the Clevity platform if no other users were selling YAPL. So that is how our client, Mr. Payne, organized the entire thing. And that's why I say so, that we have to even look at the reasonable man test, because it's not always about what goes beyond, but it's something which used to happen previously also, if that may answer your question.
Yes, carry on.
So while continuing, if the court considers the reasonable man test, any reasonable trader who regularly undertook the algorithm trades on the Clevity platform, like the appellant, could not have known or wouldn't have developed the awareness that the sale of YAPL was higher at the market, or maybe it was an abnormal situation. Thus, it still contracted and contended that the contract is valid. So the point above, which I just made, is supported by applying the majority of the Court of Appeal, compromising of Chief Justice Sundareshwar Menon, Andrew Fang Boon Yong, the judicial assistant, Jyot Prakash, the judicial assistant, and Robert Shelton French. In the view of the case Coin Pte. Limited versus B2C2 Limited 2020 in the Singapore Court of Appeal, the disputed trade shall not be reversed and the respondent's claim should be dismissed. Would Your Honor like a brief overview of this case?
Please. Very brief.
So all right. So B2C2 basically entered into a membership contract with Coin, under which they could make trades of cryptocurrencies with the other counterparties of Coin's automatically cryptocurrency trading platform. And B2C2 initiated the trades in exchange of Bitcoin on another cryptocurrency on the platform. However, due to the program functionality in the platform, which had consequences which was not anticipated by Coin, the platform executed B2C2's trades at an exchange rate of 250 times more than the current market in favor of B2C2. However, B2C2's account was automatically credited for the proceedings of the trade. Therefore, when Quinn's chief technical official looked and reviewed all the tables and considered there was an error and reversed them, the membership contract provided stated it's irreversible. Hence, B2C2 brought an action against Coin, claiming the reversing in trades. They stated that Coin's actions was a breach of contract between B2C2 and Coin in relation in participating in the platform, and Coin was in breach of trust. Therefore, the court ultimately found in B2C2's favor, and in reversing the trades, Coin had breached its contract with B2C2, and Coin failed to establish a mistake that would make the contracts for trade void. As a result, it also held that Coin was in breach of trust. Furthermore, Your Honors, it can be seen with the support of Coin that the judges held the contract in respect of a concluded trade, which was made directly between the buyer and the seller. Therefore, Coin's unilateral cancellation of disputed trade was a breach of agreement. The aforementioned decision can be adapted and established in the current case of the respondent and the appellant. Hence, Your Honours, by relying on Mance LJ's reasoning in Coin, the first instant court made a mistake and erred in rejecting the appellant's claim. Instead, the court should have relied upon the above majority judgment passed in Coin's case for Article 37(1)(a), as it's undeniable that disputed trade took via the domestic algorithms without human interface, thus preventing
Why
any
should
possible...
why should the majority judgment, why should the majority analysis be preferred to that of Lord Mance?
Because the majority judgment stated that even though that the entire contract has taken place, and what they did was they focused on the disputed trade should not be reversed, and the respondent's claim should be dismissed on the basis of fact that B2C2 had no awareness that this entire place took place. So even if Coin states that they were not in breach of trust, they were, because based on the platform they both were communicating against or communicating within, the algorithm was set and there was a membership contract provided that it's irreversible. So the same thing applies here. Hence, we should focus on the majority.
If that analysis is correct, that one looks at the time when the program is being programmed, then unilateral mistake will almost never apply, because it's very rare that mistakes are made at that point, where you've got this sort of situation. Doesn't that mean that the court, there's not much that the court can do, where, as in this case, it's obvious that an error happened on the platform? Are you saying that the court just can't intervene at all?
So in the judgment, if we see, the judge is correct to find that there were no terms of contractual documents, whether expressed or implied. So Quint's which entitled Quint to ununilaterally cancel the disputed trade. So I think we agree that the judge would state that there's no operative mistake. So I think it's very necessary to look at what happened at that specific time, because it's necessary to dismiss Quint's appeal in respect of breach of contract claim. And I think that's why we should focus on that instance in this case also.
Okay, please.
So continuing, so I would like to state that it's undeniable that this entire algorithm could have happened without human interface, thus preventing any possibility of actual knowledge on the appellant side, Mr. Payne, due to which the appellant could not have known that the disputed trade was a result of this malfunction, as the appellant's program beta was coded in such a way to sell Yapple on the platform, as I'd said before, as the price was based on the average price of Yapple. Therefore, Beta, however, automatically just sold Yapple for a sale at the highly inflated price on the Cleverty platform, because there were no other users who were willing to sell Yapple at that time because of the malfunction. Therefore, in conclusion, Your Honor, it is a submission of the appellant that the judge erred in rejecting the appellant's claim for the reasons stated above. As the contract was legitimate and not governed by the DIFC, the claim should have succeeded. For the foregoing reasons, I respectfully request the court to find in favor of the appellant and dismiss the appeals made by the respondent Raz Rani. It is therefore on these grounds we ask Your Honours to dismiss the appeal. Unless I can be of your further assistance, this concludes the case for the appellants. Thank you.
Sorry, you're asking me to dismiss the appeal. You're the appellant. You mean
Yes,
dismiss
so
the claim?
appeal, yes, dismiss the claim which was made previously.
Yes, that's fine. Thank you. So if there's nothing else from you, then whoever from the University of Reading is going to be doing the junior counsel.
Yes, that would be me again.
Excellent.
Yes. So, if you may please the court, I am going to represent Ms. Rancy on behalf of her about the second grounds of appeal. So, as my learned friend has mentioned about the Article 37(1)(a), I will not repeat it, and I deem Your Honour would have what is about in mind. So, the problem of the appeal is that if Mr. Payne has known or ought to have known that the same mistake is going to happen, and he would have responded the same. And judging by the facts of what Miss Rancy was going through, it was that she wrote an algorithm that is going to have the fairest price in the market. And when Cleverty, the online platform, has undergone the routine update, that's there was an error, and then the disputed trade happened, and it all happened when both parties are asleep, which is presumably reasonable to assume that it is late at night, and the glitch is only for 30 minutes when it was being detected and fixed. So would it sound reasonable for Ms. Francie to not have noticed the mistake and realized in the morning or when she has woken up that such contract has been made without the normal terms and conditions that she has signed up for? So Ms. Rancy cannot be found liable, as it is clear that she did not find it a very reasonable mistake to have made, as it is a routine update, not being thought to be a very special update, that it may alter a lot of software programs on an online platform. So she could not have imagined such fault to appear, and therefore has caused such a huge amount of money, amount of loss of money, which it is as huge as of 250 times of the original market price. She cannot exercise the skills as a reasonable trader as she was, and to be aware of this problem.
If you create, sorry, I have a question for you. If you
Yes.
create a computer program and you authorize that program to trade on your behalf, and then you go to sleep, don't you take the risk that whilst you're asleep, your computer program enters into a trade which may be disadvantageous to you, and had you been awake, you wouldn't have entered into it, but you have chosen to trade in this way, and therefore you take the risk that your computer program concludes a trade that in hindsight, and one might say the cold light of the morning day, you regret. That's not a mistake, is it? Because you did, as your opposite number said, you deliberately programmed that computer program to operate in the way it did, and at the time that you programmed it, you weren't making any sort of mistake. You were acting entirely intentionally.
Yes, thank you for the question, Your Honor. The main issue of the fact is that it is on a routine update. It is not something out of the ordinary, and which is expected to have undergone several times before this special routine update that has caused such a huge loss of money for Ms. Rancy. It is a matter that is not about regret or it's not about the matter of regret of she has delegated this belief or faith in the algorithm that she has written, but she has believed it in the sense of it's operating in Cleverty, the online platform. It's operating in a normal sense and normal condition, as it is what she has consented to, as she agreed, but not to the extent of such such mistake that has been made, or it has shown, as it is not talking about the percentage of 80 or 90, but by times like 500% of an inflated rate of the limits for the transaction to be allowed. So if it is considered as like believing in your algorithm, yes, you do believe when you have written it and agreed to the terms and conditions, but in a sense that it is working accordingly, but not within the mistake, because you cannot, because as a reasonable trader, you cannot just assume every mistake that is going to happen. There is always something out of the blue. So if it is concluded to be for Stransky to consent with the algorithm running with the mistake, then would it deem not too reasonable for the online platform to work? So yes.
Why does it make a difference that
Proceed.
the reason that there were no other participants in the market was due to an error on the Cleverty platform? I mean, imagine for some reason that all the other participants on Cleverty had simply decided to cancel their accounts. They were no longer interested. Both alpha and beta would have performed in exactly the same way, and the same contract would have been concluded. And that wouldn't have been as a result of any technical error on the Cleverty program. Can't you therefore say that the programs in concluding this sort of contract were simply following the instructions that had been given, and the parties who program them take the risk that if they give basic instructions, they may not foresee all the changes in market conditions, but they still intend the programs to operate in those conditions?
Yes, Your Honor, as being said, not said, but mentioned by your point, as in when other users of this platform has exited this platform, a reasonable belief is that it is not going to exit within 30 minutes. That it's just left with both parties suddenly. So, and if it is gradually decreasing of the users, and in this sense, then I believe that a reasonable trader would also find something peculiar about the market price. Maybe that's going to be a fluctuation, and as the limit is 50,000 US dollars, it is reasonably to assume that people not having enough money to fund this, to join this online platform, as in they're resigning for this platform. So if that is the case, then the average price of what Ms. Ramsey has programmed into beta can be shown by several attempts of buying of Yapple, as in the price would increase in this sense. So this it is undergoing under normal circumstance, or the normal condition, the normal changes in market. But in this case, is within 30 minutes. It's not that it is not it's not reasonable to have assumed that users apart from both parties are just going to leave, and therefore leaving just Mr. Payne and Ms. Ramsey to be left on the platform and deal with each other. May I proceed?
Yes, please do.
Yes, thank you. So, so as I was saying that Ms. Ramsey was asleep during the disputed trade, she was aware of the error at the time and therefore cannot stop the transaction. And it is reasonably believed that at that time of the glitch of on the platform, a reasonable person cannot react to it. And so so yes, that would conclude my submission as in responding to the junior counsel's submission.
Thank you very much. In which case, there is 5 minutes of responsive submission from the junior counsel for the appellant.
Thank you, Your Honor. So just to start off by stating, as stated by the junior respondent, a unilateral mistake cannot be invalidated just the contract cannot be invalidated just because of a unilateral mistake. So even if there was a mistake committed, it cannot be you can't just cancel it off. Now the reason why I say this, even though Mrs. Razi or Miss Razi paid 250 times the amount, she knew of the risk. And the reason why I say she knew of the risk is because she programmed it in such a way knowing that the amounts could fluctuate. It's not going to be a standard amount every single time, and what that amount would be is unexpected. You will not know. However, our party, Mr. Payne, knew of that. He knew how he had programmed his entire program. He knew that if there was no available seller, this would be done. So he was aware of what he was doing, even if she wasn't. And if we look at the Coins case and we justify the judgment which was held, it clearly stated that the unilateral cancellation of disputed trades was a breach of agreement. So in particular, if this clause is provided or if it's even filled, the trader was notified via the platform, even if they were sleeping. And the trading contracts are not vitalized on the basis of a unilateral mistake at common law or in equity, because they did not have constructive knowledge of the mistaken beliefs by any counterparty. Therefore, the defense of this common mistake at common law failed, even if Coin had a mistaken belief as the prices, same as which Ms. Razi did. But our party, Mr. Payne, did not. He knew what was happening and he did not have a mistaken belief. He knew that if no other party was there, his prices would be this. He was 100% sure of that, and same was B2C2 in their case. The fact that the trading contracts were valid and were enforceable operated to bar any action against unjust enrichment. Therefore, I would like to say that the contract was legitimate and it cannot be governed by the DIFC. The claims should succeed and should go on. Therefore, the grounds which were put up against us by the junior respondent should be dismissed.
Thank you very much. I think that is everything. Thank you very much, all of you, for participating in this round. We will mark you and submit your scores to the organisers, and they'll let you know, I think, whether you progress to the next round. Unless anybody has any particular questions for either of the judges, I'm very happy for you all to log out.
Matthew, there was one
Yes.
thing. I was wondering if the junior counsel has performed the rebuttal on the other side.
No, there's only one. There's only one rebuttal.
I see.
So it goes appellant, respondent, appellant's response.
Respected sir, if I may, I have a question for yourself. Would it be possible to provide us some feedback on how we performed?
Yes, it probably is. The best way to do that is I'm very happy to give feedback about how you've performed, and I've taken notes of what you've said and what you've done. If anybody wants feedback, if you look at my chamber's website, you will see my email address, and if you email, maybe if you email as a team, I'll very happily set up a short Zoom call. It won't be today, but maybe sometime towards the back end of next week, and I'm very happy to give short bits of feedback on how you performed, if that's okay.
Matthew, would you mind if I give some feedback right now? Just brief overview.
Yes, by all means.
I think one thing that that stands out in this particular case is certainly the fact that it's an evolving area even for us who are practitioners. It just depends on which jurisdiction that you're in, and it becomes quite complex in terms of how you perhaps perceive it in different jurisdictions. What I would have perhaps, what I would recommend is that for you to look up the DFC rules and see if the DFC rules explicitly prohibit / permit. So while your arguments that were advanced were theoretically made sense, the fact that it should reflect in the DIFC rules is something that I would have preferred. Something on an articulation towards the DIFC rules would have been my first comment. Second comment that I would say is the reliance on jurisprudence from Singapore is good, because there is certainly a market where crypto exists, and perhaps an alternative view which exists outside of Singapore would also be something that you may want to consider, because of the fact that the more the jurisdictions that you cover, the more you would have, you would present a view to the judges that you have considered the alternative positions as well, and you have evaluated the alternative position and found them to be not applicable / they are perhaps finding favor to your argument. So that would be my suggestion. So that applies to all of you. I know that this case being such a complex case, and this being such an evolving area, we tend to you tend to assume a lot of things which may apply to a normal contract law, and which may not necessarily apply to digital assets. You may want to explore how various jurisdictions who have recently come up with laws surrounding this have dealt with such an issue. So that would be also, that will be a point that I would expect you to articulate as you move along this particular journey in DC. So all the best to you, and I wish you good luck, and I hope to see you in further rounds.
Thank you very much, sir. Have a good day.
Thank you.
Thank you, everybody. Thank you.
Thank you.
Thank you.
Matthew, do we go to the